Thank you, Shivam. Good evening, friends. First of all a very happy New Year, and I extend very warm welcome to our first webinar of 2024, and that is an overall 157th webinar on Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita 2023, which is replacing IPC and CrPC. Friends, as you are aware, that we have started this journey on 28th April 2020, and till then, without any fail, we are organizing every week our webinar on various topical interests which are useful for the corporate and the professionals. Friends, today's webinar is very important because this particular subject is not only a subject which is connected to few professional, it is connected with each and every professional, each and every company, and each and every legal community. So on December 25th, 23, the President of India granted assent of two acts, the Bharatiya Nagarik Suraksha Sanhita 2023, which consolidate and amend the law relating to criminal procedure and seek the replacement of Criminal Procedure Code to 1973, and the Bharatiya Nyaya Sanhita 2023, which consolidate and amends the provision relating to offence and for matters connected therein or incidental thereto, and seek to replace the Indian Penal Code of 1860. Now, very important thing, it is one of the oldest law, and which has since 1860, it is continuously coming. So today, we are very fortunate that we have a galaxy of speakers, those who are expert in this law. They are doing practice day and night on the criminal side. So first, I'll welcome Justice S.N. Digra. He is the former Delhi High Court judge, and he's practiced at company matter, criminal matter, labor and civil matters, and he worked in the matrimonial court, designated TADA court, special 1984, Royds court, appellate courts of MCD, rent control tribunal, and special court of Pota. So you can understand Justice Dhingra is one of the brightest judge in the Indian court, and he has passed very important decision in the country. I welcome Justice Dhingra. He's just joining. Then we have Mr. Mohit Mathur. He is a senior advocate and president of Delhi Bar Court Association. He has received presidential reference of address in the interstate Kaveri dispute and has also fought many prominent cases. I welcome Mohit. Then we have Mr. Ramesh Gupta. He is a senior advocate, Delhi High Court. He has handled notable cases including the Opar Cinema tragedy case, Rahul Mahajan drug case, 2G Spectrum and coal block cases, and National Herald cases. I welcome Mr. Gupta. He is a very senior and very learned advocate. Then we have Mr. Vijay Agarwal. Everybody knows Vijay, and every day we are finding in the newspaper some another report relating to the prominent cases. He is advocate Supreme Court and High Court. He is a chartered accountant by profession and as well as lawyer. He is primarily known for the popular scam 2G scam, Spectrum cases, and then fraud case of Punjab National and various other cases. And today, whatever new cases coming, you can find Vijay Agarwal's name. So I'll welcome Vijay for this program. Then we have our own partner, Mr. Amit Khemka, who has been practicing as a litigation lawyer in Supreme Court, High Court, and other court of country, and he has handled large number of cases involving complex issues, some of which has made headline. And today he is the expert in PMLA law and advising various corporate related to this. And the last, we have Ravi Prakash, who is an associate and advocate partner at corporate profession. So I welcome Ravi, and I welcome Justice Dhingra, who has just now joined. So friends, as I have mentioned that this the two laws which has come, it will really change the face of Indian legal system. Now, the point is, when I was seeing the statement of the object and reason, then 2, 3 issues came which emerged that why this law has come. So, Shivam, just can you go for presentation? So, first is the historical background. The document outlined that historical development of the Indian Criminal Code, the need for review of reforms. It emphasized need that why this is required for contemporary need and challenges. Then they mentioned the focus area. They mentioned that that include strengthening a law of an order, simplify legal process, and ensuring the law relevant for today's context. And then they mention in the statement that aim for speedy judiciary justice. A significant objective is to provide speedy and effective justice to the common man, which is the main problem of Indian legal system, specifically the criminal side. Then stakeholders consultation. The process reforms involve consultation with various stakeholders, including collaborative approach of legal reforms. Then ease of living. That was another object of this particular thing, that it should be more accessible and less cumbersome. And then contemporary relevance. And the contemporary relevance means that there is a clear intent to make the law applicable and effective in the modern era, addressing current societal and the technological changes. So these are the statement object which were when the bill introduced in the Lok Sabha. But when we studied about this and we identified the reason of this law and studied both the law, then the main issue which came out, that reason of enacting the new criminal laws, one is the colonial legacy, because this was a, you can understand, this law which came in 1860. Okay, you can understand this is a more than 140 years old law. This required a law, and it was passed by the English period, British era. So there are so many things which are connected to that time, so they want to change. Then advancement of technology, that is another issue which is very important, because rapid technological changes is taking place, and that rendered old law inadequate, particularly the area like cybercrime, digital evidence, privacy, updating law, ensuring their effective address of crimes and issues arising of new technology. Every day we are finding that some fraud is taking place relating to the cybercrime, relating to the technology. So this law was not inadequate. Then simplified and streamlining. The law has been become complex over the time, and there was a confusion amongst the legal practitioner, and there are so many legal cases the judiciary was passing, so they were conflicting with the law. So that's why there was a need of simplification. Various report highlighted the need. The 146 report of Home Affairs, that is also recommended that there is a need of comprehensive review change in the criminal justice system of the country. Now, other than this, there are so many other points also, like international standards and globalization, because what is happening when the law is there, then you have to, today the market is globalized. So you cannot face the challenges of Indian problems. You have to see the global problem also, and you have to meet out the global standard also. The legal loopholes and ambiguities. That is always whenever you bring out any law, after some time there are some loopholes people will take out, and the regulator is always active on this part and to remove the loopholes, and simultaneously the ambiguity where the more and more judicial issues are coming to the court. Then judicial efficiency and effectiveness, that is another aspect, that the cases are delayed, time-bound system is not there. So how to reduce the backlog, that is another reason. Then public demand, that is also because whenever there is some issues are coming, some crime is coming, then the public is also asking to change this. So the pressure group is also working on this. Then political and ideological shifted, that we have given the government is changed, their ideology is different, and the one government ideology is different. So they want to bring out this gap also, and they want to think that how the legal reforms and new administration will seek to implement with the vision and law and order of that particular political ideology. Then addressing discrimination and inadequate inequalities, and this is a continuous process. today what is equal, tomorrow it will be unequal. So you have to understand today what people are taking advantage and discriminating something. Tomorrow it will be identified as a wrong thing. So they have to address this also, and they have to protect the right of the marginalized and vulnerable group also. Then harmonization of law. Government sometime update law to harmonize with other existing law, and the other law is saying something like this law in the PMLA law is also, the experts are saying that it's creating, it will create some confusion. So we'll discuss this issue also. Then enhancement, punishment, and deterrence. Sometimes what is happening that some punishment is there, but tomorrow that punishment is not sufficient, like gang rape. So gang rape, it is not a punishment which is rape case. It is now prescribed of the capital punishment also. So to do this, and the lynching of the person, that is also another aspect. So you can understand the enhanced punishment and deterrence is required after some time. Then in economic consideration, economic changes are also changes with the time, particularly like corporate laws, taxation, and financial regulation, where the earlier provision were not sufficient. So they have to change, and they have to bring out the today's requirement. Then international relation and security concern is also there, because international crime governance often require that they should meet out with the international standard. So that is the point, which is the main reason of new criminal code which is prescribed. And then if you see summarize and see this, that what is the objective behind this? So the strengthening law and order and focus on the simplifying legal process. That is the purpose of the new IPC, Bharatiya Nyaya Sanhita, to make existing law relevant to the contemporary situation and provide speedy justice to the common man, to streamline provision relating to offense and penalties, and to give precedents on dealing with offense against women and children, which I told, the vulnerable group which is required. And the most important thing is the CrPC thing. This is Bharatiya Nagarik Suraksha Sanhita 2023. That is talking about the how do in this IPC implemented. So to create a fast and efficient judicial system, to streamline the complex legal procedure, to deal speedy and large pendency of cases in the court, and to increase the use of technology in the legal system. So they have prescribed in this the process, how it will move, and we can, I have just explained to you, these are the issues which has to change with the time. Today, technology and the new things which are taking shape, societal changes are taking place. What was the law? Live-in relationship was not there earlier. It has come now. So they are making law. They are working out that how the people misutilizing the law. The economic system is there. The legal system is there. And then the global system is also taking shape. So all these things are the requirement of this. So these are the changes which has come. So this summary I have given. Now I will request Ravi Prakash to give a brief overview about the two new laws. What are the major things has come? So it will be useful for everyone. And then we can request after that Mr. Justice Dhingra to give his comments. Ravi, over to you.
Thank you so much, sir, for giving the broad overview of these two laws, as well as the legislative history of the laws that have come, replacing the age-old laws based on Victorian philosophy. On the panel, Justice Dhingra, Mr. Amit Khemka, along with other doyens of the bar. Any criminal legislation across the world find its roots in the set of principles that guide criminalization and penalization and prescription of punishments. In India, because we had a colonial history, the criminal justice system had been predominantly shaped by laws and regulations inherited from British colonial era. Whereas the time passed, the legal foundations based on which these laws were made, and the morality also, particularly the Victorian morality as we call it shifted and underwent significant changes. And therefore, there was a need to align these laws with the reality of modern day. And therefore, this legislative exercise was undertaken. If you would see the standing committee reports of the parliament, they have lauded the effort by calling it a significant milestone. And a lot of consultative process has undergone before these laws were put up. In fact, the Ministry of Home Affairs states that 18 states, 6 union territories, the Supreme Court, 16 high courts, 5 judicial academies, 22 law universities, 142 members of parliament, and around 270 MLAs, apart from public, have given their suggestions to these new laws. And as Pawan sir indicated, the discussion is not new, is not novel, but was ongoing since many years. If you see the Law Commission reports of India and other committees like Base Barua Committee, Vishwanathan Committee, Malimath Committee, Madhav Menon Committee, they all suggested section-specific amendments in criminal laws. And apart from it, Parliamentary Standing Committee in 111th report in 2005, subsequently in 2006 by their 128th report, and in 2010 report, that is 146th report, as sir also mentioned, they all suggested that we need an overhaul of these laws and we need principles and set of guiding principles to criminalize and penalize, prescribe punishments for the offences, to have a modern day criminal justice system in India. Now, in the background, if you see, it was in 1834 that the consultation was done with First Indian Law Commission under the chairmanship of Lord Thomas Babington Macaulay, who envisaged this, who recommended that we must have a penal code, and therefore this penal code came into being in 1860. After that, immediately, a criminal procedure code for India was brought in 1861. In 1882, uniform procedures was provided for entire India. And thereafter, there was subsequent amendment. And this 1882 legislation also was short-lived because in 1898, it had to be supplanted by a new code. After the independence, the commission again conducted a thorough inquiry of reviewing the old code, and that resulted in 41st report submitted in September 1969. And based on these recommendations, the Criminal Procedure Code was drafted and came into force on April 1st, 1974. Now, and this is also fairly old today. So these are the sets of laws, just to give a background to the audience. These are the sets of laws, old and archaic, which are sought to be revamped by these new legislations, the Bharatiya Nyaya Sanhita 2023 and the Bharatiya Nagarik Suraksha Sanhita 2023. The former replaces Indian Penal Code when comes in effect, and the latter would replace Code of Criminal Procedure 1973. Shivam, could you move to next slide? The timelines, sir has already covered. It was introduced in, I'll just briefly run through this. In August 2023, it was introduced in Lok Sabha, then was referred to the Standing Committee. And the report of Standing Committee on all three legislation, two of which we are concerned with today, was submitted. On December 12, 2023, it was withdrawn. and it was replaced by the legislations which we have today, which have received the presidential assent. Now, we would also, while discussing this, I would quickly also go through briefly discuss the recommendations that the committees made on various aspects which made headlines and were also buzzword for quite some time. Next slide, please. So let us talk about the applicability of the new criminal codes at the threshold. They will come in force on such date as the central government may by notification official gazette notify. And the central government, obviously, as is the case with other legislations, has the power to notify provisions altogether or in a phased wise graded manner as deemed fit by the government. But as of now, no specific date has been notified for implementation of these new framed laws. So therefore, the current regime is governed by IPC and CrPC as we have been seeing it to date. Next. So let us quickly discuss what are the key changes introduced in the Bharatiya Nyaya Sanhita first. These do not encompass the entirety of changes brought in, and because these have been the laws governing the criminal justice system of India, the issue is far more nuanced and complex than it would appear. And considering that the laws are very new concepts, many concepts are novel, one could not contemplate with certainty what all nuances will pan out going forward. So this is just a highlights of what key changes are introduced. Chapter 5 of BNS, it increases the threshold for victim to be classified as the victim of gang rape from 16 years to 18 years of the age. Also, the age-based parameter for differential punishment for gang rape of a minor girl has been removed. So therefore, in this sense, the dragnet of the law has been made rigorous and for good reasons, considering the ground realities of our country and the incidents that we have faced, challenges we have faced in protecting women. Then, section clause 69, that is the sexual intercourse by employing deceitful means. This is a new provision which has been added to punish people who employ deceitful means like false promises of marriage to obtain the consent of the woman and get involved in sexual intercourse. Then snatching has been made an offense. Again, a problem which plagues the country, both metropolitan cities and all other cities alike. And therefore, it has been proposed that this will be made an offense in every part of the country, which punishes the act of forcible seizure or grabbing of movable property. Causing death by rash or negligent act, the punishment here has been increased 2 years to 5 years. But for the medical practitioners, the punishment will remain 2 years. Next slide. Mob lynching has been added as a new offense, and it has been now tagged in the category of murder in clause 103 of BNS. Then sedition is removed as an offense, and I'll come to it later on in little bit more detail, because some aspects of it has been retained, but and what it now penalizes is the exciting or attempting to excite secession, armed rebellion, or subversive activities, encouraging feelings of separatist activities, or endangering the sovereignty of or unity and integrity of India. The offense of attempt to commit suicide has been deleted in BNS, and the law is aligned with now aligned with the Mental Health Care Act of 2017. Although a new section 226 has been added in BNS to punish those who attempt to commit suicide with the intent to compel or restrain the exercise of lawful power by a public servant. Next slide, please. Then in BNS, a new form of punishment, which is reformative in nature, has also been introduced, which is community service. Although in legislation this has found its place now, but judicial authorities have been passing orders considering the reformative theory, and orders of these community service have been passed. One may see the orders passed by Justice Nazmi Waziri. I'm just quoting it as an example, where he would instruct plantation of trees by the offenders. And then voluntarily causing grievous hurt, a new provision 117 has been introduced in BNS to provide stringent punishment for such act of grievous hurt which result in persistent vegetative state or in permanent disability. And therefore, if any grievous hurt results in persistent vegetative state or permanent disability, it will attract higher punishment, which shall not be less than 10 years, but which may extend to imprisonment for life. Now, let us discuss about a few areas of concern, although I feel there would be many to legal minds. And we would have doyens speaking about the nuances of the law, and I'm not going into it. But it is felt that some aspect of sedition, as it was contained in IPC, still remains, although in the other form. It is still unclear how susceptible to mischief it would be, but the aspects remain. Duplication of offences with other special laws. As we all know, that while IPC was an old and fairly old law, with time and progression, special acts were legislated which also prescribed for punishments, designated offences, and those were not duplicated in IPC. But now in BNS, there are some overlaps with organized, such as new offences have been tagged here, such as organized crime and terrorism. Apart from it, there are also some offences which would fall under Food Adulteration Act, which are also here. So now that is an overlapping feature of BNS. Now let us come to the key changes introduced in the Bharatiya Nagarik Suraksha Sanhita 2023. So the concept of zero FIR has been introduced. Once the zero FIR is registered, and this is through section or clause 173, once it is registered, the police station has to transfer the said FIR to the police station which has got jurisdiction. Therefore, from the victim or the complainant being required to run from pillar to post, the baton is now kept at the hands of police authorities to act timely, swiftly, and register the FIR. That has been a challenge that the courts had been navigating and seems to be addressed by BNSS. Now, FIR can also be registered via electronic communication in the prescribed form, although there are formalities which would be required to be done in that case. As per clause 107, the BNSS seeks to provide the magistrate with the powers to attach property identified as proceeds of crime or which is found to be involved there. The intention behind this provision seems to be either to secure the presence of fugitives or confiscate the properties of fugitives who are evading summons, investigation, or trial, therefore causing aberration in administration of justice. And also, apart from it, also lading the courts with piles of cases, causing delays and access to justice. When investigation could not be completed in 24 hours as against the settled law, and there are discussions about it already across the legal fraternity, clause 197 of BNSS, it now clarifies that the police custody can be sought for a maximum of 15 days. However, it provides that the same may be taken either at all at once, or in staggered manner. Use of electronic mode at the stages of investigation, inquiry, and trial is introduced. This is in line with the objective of these legislations to take advantage of the modern day technologies or to align the legislative framework with the technological development that the human civilization has made. And then adherence with timelines. So one of the major objectives, as also recorded in the Statement of Objects and Reasons, is to overhaul these criminal laws to provide a time-bound justice delivery system. Although there is an old adage which says that justice delayed is justice denied and justice hurried is justice buried. But a balance needs to be struck between both the extreme poles. And therefore, with that objective, an overhaul has been attempted. It provides that the charges are to be framed within a period of 60 days from the first date of hearing on the charge before courts of sessions. A judgment of acquittal or conviction has to be passed within 30 days from the completion of arguments, which can be extended by 45 days only by giving specific reasons. Then Clause 173 provides for preliminary inquiry, which can be done for offences which are punishable with 3 years or more but less than 7 years of imprisonment. The timeline to complete such preliminary inquiry is fixed as 14 days, and such preliminary inquiry could be conducted only with the prior permission of the officer not below the rank of Deputy Superintendent of Police. As a safeguard, this has been provided. Summary trial as a concept has been introduced. To reduce the burden on judiciary, Section 283 makes summary trial mandatory for petty and less serious offences like theft, receiving or retaining stolen property, house trespass, breach of peace, criminal intimidation, etc. Timelines for preferring mercy petition in death sentence cases are also provided. Before governor, now the mercy petition must be filed within 30 days of the order of conviction and 60 days before the president. Some reactions that have come, as I also discussed while discussing the key changes in BNSS, is the procedure of police custody seems to be altered, which may be susceptible to misuse. And also this attempt to commit suicide, this could be also seen as a double-edged sword, susceptible to misuse. And then at this juncture, the statement of Dr. Bhimrao Ambedkar comes to my mind that it is not the legislation, but those who are handed with the responsibility to administer the legislation who will determine how effectively it will be used and how judiciously it will be used. Therefore, Article 22 of the Indian Constitution and Section 51 of CrPC, along with other allied provisions and precedents which are already there on the point, it prohibits detention in police custody beyond 24 hours. But as per the BNSS, the magistrate is empowered. Police can empower police custody up to 15 days in case the investigation cannot be completed within 24 hours. This could lead to bail being denied during this period if the police argue that they need to take the person back into the police custody. Another area of concern flagged by many is data collection for criminal identification. CrPC was amended in 2005 to empower a magistrate to obtain handwritten or signature specimens from arrested persons. The BNSS now expands it to empowering magistrate to collect samples. And this is not only restricted to these two categories of samples, but it could span across wide variety of samples such as finger impressions, voice samples, etc. And this change came into being. Earlier it was restricted. The parliamentary committee recommended it that it be changed and it should not be narrowed down. And therefore the marginal heading of this particular clause was altered. As an aftermath of these new legislations, we have seen some protests by truckers and taxi drivers across various states on the increase of punishment in hit and run cases. And also a PIL is filed in Supreme Court challenging these three legislations. Although more details would come as we move forward in future to see what would be the fate of the PIL and the Supreme Court. But a review of the literature contained in these legislations and the standing committee reports of Parliament, they do welcome these legislations as a milestone and momentous change in the existing old, archaic, and irrelevant provisions that were contained and continuing in these old laws. Okay. So that is all from my side. I would now hand it over to Pawan sir.
Okay, thank you, Ravi. Thank you very much for giving a brief overview of this law and the more important point. As you all are aware, that today in our panel, we have expert, we have judiciary person also who was an advocate, and then he became the judge of district court and high court, and who has given a lead the cases which were the highlight of the headline of the newspapers. So I will request Justice Dhingra to give his view about this law, and you have handled this. So what is your view? How this will change the country's problem of piling up cases and the specific, the legal jurisprudence on the criminal side? Over to you, Justice Dhingra, sir.
Thank you, Pawan, and good evening to all the listeners. See, the stated aim of these laws has been speedier justice. But the changes which have been brought are only in respect of speedier investigation. There are only few changes regarding pronouncement of judgment in 45 days, framing charge within 14 days, etc. There is no time limit fixed for trials. That in how much time trial of cases falling where sentences say up to 1 year has to be completed. There is no time limit that in how much period the trial of cases, say up to sentences up to 3 years or 7 years, or life sentence or death sentence are to be completed. So the area of concern is the prolongation of the trial. And given what the judicial system is, I consider that these changes which have been brought as far as speedy trial is concerned, are not going to be effective. They will speed up the filing of challan, speed up framing of charge, and that's all. Thereafter, the trial is left to the judge's discretion and the advocate's willingness. See, there are many judgments of Supreme Court where Supreme Court has stated that if a person has enough money, enough power, he can prolong the trial of a case to as many years as he wants. And this scenario is not going to change. The reason is very simple, that in order to change this scenario, instead of reining the police in investigation, asking them to file speedier challan, etc., we need to rein the judges and the advocates. for which no law has been made. Today our courts are, you see, mostly in the grip of advocates. If advocate says that I will not cross-examine the witness today, the witness is not cross-examined. The reason may be any. He may say, I am not prepared. He may say that I have urgently to go. He may say, I have, another case coming up and I have to rush there. So the judge may close the cross-examination, but he would go to High Court, get this order set aside, and going to High Court, the process of going to High Court, getting the order set aside, takes about 6 months' time. So if you don't give adjournment at the request of the advocate at trial court, he gets the same adjournment from the High Court. Even if High Court refuses, he gets the same order set aside from the Supreme Court. Unless this tendency of the judges does not change, and unless we sensitize our judges for speedier trial, the speedier trial is not going to be there. Then we have huge pendency today. 5 crore plus cases are pending before, district courts, trial courts, High Court and Supreme Court. Then approximately equal number of cases are pending before tribunals, before administrative courts, before revenue courts, and other courts. With this pendency, how this pendency would be dealt with? Nothing has been said, and perhaps nothing can be said. We need to reform our judiciary thoroughly if we want that this pendency and quick trial and speedier trial should be there. There is a concept of fair trial. This concept has not been clarified in CrPC. What are the parameters of fair trial? Not giving adjournment, does it fall to unfair trial? How many adjournments should be given? The law is already there that you cannot give more than 3 adjournments. And perhaps there is not a single case in High Court or Supreme Court where only 3 adjournments had been given. Even in trial courts, you won't find judges adhering to this law. In 1973 and 76, we had brought changes in CrPC and CPC. In CrPC, it was provided, and same in CPC, that the effort should be made to examine the witnesses on day-to-day basis. There is not a single incident where this law was followed in spirit. There are only few instances where, fast-track courts were created and the judges did day-to-day trial and finished the trial within a month or 2 months or 3 months. There is another aspect. If a judge makes sincere effort to speedily try the case, which he considers that this case is important and should be speedily tried. See, he is accused of burying the justice. On what ground? Only on the ground that he gave speedier trial. There was recently a case where action was taken against the trial court judge because he was suspended, rather. That he tried and finished a case within 1 month. And a High Court had taken action against him. the poor fellow had to come to Supreme Court, and the Supreme Court set aside the action taken against the judge. Now, what are the norms of Justice Harid and Justice Bharit? What does that mean? Whether you have refused to examine the witnesses and proceeded with the case, or you have refused to give adjournments to the advocates on their demand. Does the advocate have unprecedented power to seek adjournment in any case at any point of time? If the courts are to be run by the advocates, these things will continue to happen. And unless powers are given to the court that they will not allow adjournment and would examine the witness day to day, this problem of speedy trial is not going to be solved. If the judges give adjournment, unnecessary adjournment, for example, the advocate says, I am busy in another case. Advocate says, I have to go to Bombay today. He says, I have to go to the school of my child. I have to go there. Or he takes an excuse that my client is, not well. These problems, so one problem has been dealt that even in absentia, you can examine the witness of the client, witness of in criminal case. But I doubt that the courts will see upon it kindly. And this may be struck down by the courts on the ground of unfair trial, irrespective of the fact whether the presence of witness, presence of accused was required or not for examination of witness. It is not that that the advocate has to keep on asking the accused that whether should I ask this question or not? Should I ask this, take this stand or not? The advocates generally prepare the stand beforehand. But the presence of accused is so far was must. And therefore, on any excuse, the adjournments could be there. That is why trials used to drag. Fixing of time limits also doesn't help. You see, in Hindu Marriage Act, the time limit is there that you should decide a case within 6 months. I have yet to see a case where under Hindu Marriage Act, where 6 months has been the time in which cases have been decided. See, as far as summary trial is concerned, see Section 138 of Negotiable Instrument Act provides that all cases of check bouncing shall be tried summarily. But what the magistrates have been doing, they have been trying these cases as if they were dealing with murder trials. Each case had taken from 5 to 10 years, even under dishonor of check, in deciding. Nowadays, even issuing of summons for under Section 138 cases in Delhi is done after 6 months, which is the period given in the Act that you have to decide the case. 6-month date is given that you come after 6 months, I shall consider whether someone should be issued or not. So, unless we have a trained judiciary, trained and concerned with the people, a judiciary which is devoted for the cause of justice, then only we cannot have superior justice and justice to the people. We have, you see, the effort, I won't say that these entire changes are useless. I'm only saying that these changes, as far as speedy trial are concerned, are not going to help. Otherwise, some of the changes which have been brought, most of the changes which have been brought in Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita, they are welcome changes. But much more is required to be done. And why it is not done? Because there is a strong lobby of advocates and strong lobby of judges also, which would not allow such changes to be brought in, where speedier trial can actually take effect. I give you an example. In America, an advocate has to obtain license of each state for practicing there. One advocate did not appear on one date in the case fixed for him. The judge ordered for cancellation of his license for that state, and he could not practice in that case. In India, you see, the judges have no power for cancellation of license, and the Bar Council does not act in this manner. And I remember a case of Mr. Mishra, who was president of the Bar Council, or holding high office. He, in the open court in Allahabad, abused the bench, and the bench suspended his practicing lessons for a few months. He came to Supreme Court, and Supreme Court set aside the order. See, even 2 days back, I read a news where a judge, advocate was shouting in Supreme Court in the Chief Justice Court. The Chief Justice had to tell him, in 23 years, I have not allowed anybody to shout at me. How you are shouting at me? But the fact is that all the powerful advocates, they shout at judges, and
Sir, please ignore that. That is the poll for public.
but it is blocking the view.
Okay.
So, see, in the trial courts, it is very common practice of the advocates to shout at judges. And they have been shouting even in High Court. Some judges have been throwing files on the bench, desk before them, saying, if you are not listening to me, I do not want to argue before you. This has happened in case of very prominent advocates. You see in Supreme Court also, where the prominent advocate threw the files on the desk and said, I won't argue in this case. And ultimately, some senior advocates have to, you see, intervene and brought a rapprochement between the judge and the counsel. I fail to understand who is master of the court, whether they are the advocates or the judge. If advocates are the master of the court, then this system is doomed to vanish. It is already having little respect in the eyes of people. People do not, they are scared of going to courts. Why? One, because their amount of fees which they have to pay is too much, and most of them cannot afford it. Second, the time which is taken the courts and the perils of visiting the courts is also such that most of the people do not like to go to court. If you talk to anybody about the courts, I see about 2 days back, somebody came to me with a problem. He stated that, you see, he was on bail and wanted to argue his own case. The court said, no, you take amicus curiae. I'm talking of High Court. The High Court allotted him an amicus curiae. he requested the court that I do not want amicus curiae. I can argue my own case very well. I know the facts. And since amicus curiae is a friend of the court, he won't take instruction from me. He will argue as he likes. So I don't want amicus curiae. I can argue my case. What the court did, court cancelled his claim, sent him to jail. Only on the ground that he did not agree to have an amicus curiae. I'm talking of Allahabad High Court. Now, if we have such judges who are not concerned with the people, and if we have most of the judges in judiciary who consider that they are above law, then you see, fate of judiciary is doomed. And the fate of justice is already doomed. Because what in the courts, we do not do justice, one thing. The judges decide the cases. They are not bothered whether justice has been done or not. And decision has to be according to law. Law has not to be what the legislature has laid down. Law is what the judge considers is the law. This is the situation. When this is the situation that the judges consider that they are above law, what they say is the law, and they will decide case according to what they feel is the law, then you see law can never be certain. Law is never uniform. Law changes with face to face. Law changes with advocate to advocate. Then you see there is no justice in this court. This situation has not been adverted to and has not been addressed by these changes. They are welcome changes. After approximately 142 years, we have, you see, at least brought changes in our criminal laws, in our procedural laws, saying that, you see, we have at least given an Indian name, Bharatiya Sanhita and Bharatiya Nyaya Sanhita, Bharatiya Nyaya Sanhita. But the changes which have brought are welcome changes, but they have not addressed the problem of speedier justice. At trial court, we have babus instead of judges who consider that they have to give number of units. Once their unit is over, they're not bothered how old is the case, how much old it will run. And in High Court and Supreme Court, we have lords who are not, you see, concerned with the common man. They are concerned with only few cartels, where, you see, advocates rule the High Court and Supreme Court. So this problem, unless is addressed, speedier justice is not going to be there.
Okay.
That's my opinion.
Okay, thank you very much, sir. You have raised certain issues which are the fundamental point, and these points have to be addressed. Without these addresses, whatever law you are making, it will not be helpful. So now, because I have all the speaker has come, so Vijay, he has earlier come and he has requested, but he has to go somewhere. So I'll just request Vijay Agrawal to say his point, then Mohit can point his. So Vijay, please, because I know you have requested me to come early. Yeah, please, over to you.
First of all, Pawan, it is a pleasure, and to get to speak just after Justice Jhingra, we've always admired. And I used to appear in the very beginning of my career when my head was full of hair. Now I have lost all of them. And Pawan, seeing you on screen is also great. I still remember the moment I was qualified as a chartered accountant, I came to you as my boss, and you took my first interview, though you selected me. And I thank Mr. Mohit Mathur to give me the way. Of course, President of the bar has to accommodate his voters. So now I will speak as a Bania chartered accountant lawyer. I will speak only to the point commercial aspects. Now the thing is, in this BNSS and this Bharatiya Nyaya Sanhita and this Suraksha Sanhita, this Adhiniyam I have not gone through as yet. Now in these two, there are two, I'm telling you a couple of the opportunities and the problems also, opportunities for the lawyers and otherwise, commercial opportunities, right? And otherwise. Now, please see, first of all, there are two things. Now, police is, earlier I used to say, I would tell the IPS officers whom I know that you are nothing today, you are a Dandawala Chokidar, today the power is with only ED. Or with the ED, but now there are two powers given to the police. Police has become supreme. Now the police has become the prime thing in this country. There are two powers which have been given and which have not been much talked about, or maybe it is my ignorance, I have not read this. One is they have given the powers bigger than the enforcement directorate. What is the difference between the normal police and the ED? Why everyone is afraid of ED? Why the ED can topple governments? Because they can attach any assets. Now, earlier we used to have only section 102 CrPC, where they would attach anything where there is somebody is suspecting a crime. Now they have added section 107. Now, if you see section 107 B and SS, it provides that if a police officer making investigation has reasons to believe that a property is derived or obtained directly or indirectly as a result of a criminal activity, all these words were never there. All these words were there in the Prevention of Money Laundering Act only. So they were never there anywhere. So now this has come in CrPC. Now the police officer is above a ED officer. And moreover, when they brought the PMLA Act, they said that we are bringing the PMLA Act because there is no such provision for the attachment of the proceeds of crime. See, basically the motto of the law is that the crime never pays. If you commit the crime, the police will take you. And if you are enjoying the property, then ED will take you. Now police will take you for everything. But at least in PMLA Act, there were certain safeguards. Once you attach the property, it was valid only for 180 days. Within 30 days, the ED officer was supposed to go to adjudicating authority. There is no such safeguards I have been able to see in section 107 of this BNSS. And it says in the interim, there can be an ex parte attachment. And then the police officer doesn't like someone. He goes to the judge. After lodging the FIR, he says that I presume that this property is with a crime and you please attach everything. And the judge can do it even ex parte. And that ex parte will continue for long. Please see that this 107 also provides that if the court of a judicial magistrate is of the opinion that issuance of the notice under subsection would defeat the object of attachment, the court of judicial magistrate by an interim order pass ex parte direct attachment of the cedar, which shall remain in force till the order in 6 below is passed. And and the 6 below is regarding the distribution of the crime money between the affected party. So the police officer will now also wear the hat of the ED officer and much stronger. Now the people do not have to look for deputation in ED. They want power. They can stay in Delhi police or any police for that reason to concern. And in between, though, I want to continue with this BNSS, I want to jump over and tell Makoka is also brought from the black door. PMLA is brought, and this PMLA is brought through this section 107 in BNSS, and a whole Makoka is brought in this Bharatiya Nyaya Sanhita 2023. Now they have defined section 112 as organized crime, and this is, see, whatever I read in 107, BNSS is nothing but copy cut paste, removing the safeguards of PMLA Act in BNSS. Same way, there were safeguards in Makoka. There are some senior officers who are supposed to give two kinds of approvals, which we used to challenge and get a stay. So some two approvals were required for the FIR in this or the proceedings in Makoka for the organized crime. So if there is one charge sheet against a person, and they have included everything under the sun. They have included economy. So on the builders, there are a couple of FIRs. On the people selling the properties, there are 2 FIRs. So now everyone can be roped in for this organized crime, which they have defined, in section 111 of BNS. It says any continued lawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract link economic offense, such a general term, cyber crime, trafficking, drugs, weapon, illicit. So, or any of these things, so there can be an organized crime syndicate. And economic offense meaning is criminal breach of trust, forgery, counterfeiting, mass marketing, running any scheme of several persons, and defrauding the banks or everyone. So now every client, see, when you start practice as a lawyer, initially you get a Dahej case. And then you feel that, okay, I'll get this, I've got a bail for a 498A, now I'll get a domestic violence act case, now I'll get a 125 CrPC case. So now in this, all the clients are going to be prosecuted under this organized crime. So nowadays it happens that there is a CBI FIR, so CBI RC, so the client comes after a few days running for ED, attachment of property, then ED complaint, then he comes running for SFIO, then GST, black money. Now they have in this, police was not there because I was generally dealing with these agencies, but now please see the police. If there are 2 charge sheets, then the police can invoke this organized crime, and those safeguards which were there in Mokoka are not there. So some senior officers, at least I could not find that though some senior officers approval is required or something. So it says if there is it says continuing lawful activity means an activity prohibited by law which is cognizable offences punishable with imprisonment for 3 years or more undertaken by a person as a member of the organized crime, and in respect of which one or more charge sheet has been filed within the preceding period of 10 years. And then it will also entail a judicial controversy that we will argue whether it is prospective or retrospective, whether the charge sheet should have been filed before or charge sheet should have been filed after. So basically it is Mokoka from the back door. So please be clear that now for the police also, now there is going to be these 2 provisions, and if they invoke 107 of B and SS and 111 of B and S, it is a very heavy powers. And what pains me at this cost of repetition, I am stating what pains me is that the safeguard which were there in PMLA and Mokoka, they are not there. Now 3 more provisions in 3 lines I want to draw the attention of this August gathering. Now this is, and I also see Mr. Ramesh Gupta, he started in the courts holding the books, standing behind him. Sir. So now you please see this section, the basic concept, somehow there is a confusion in the basic concept. Basically, whether the law student, lawyers, judges, there is a lot of confusion. People consider cognizance and summoning to be the same thing. Cognizance is under section 190. After that, the charge sheet is filed or the complaint is filed. If a complaint is filed, there is an examination of complainant under 200, then the summoning happens in 204. Now, let us say goodbye to all complaint cases. Firstly, in 190, which is now 210, they have simply added that the complaint can also be of a special law. That is very fair, whether they write it or they don't write it. That was all right. In 197 CrPC, where there is 218, they have incorporated the provision of the judgment of the Supreme Court, where it says that in case the sanction does not come within 120 days, it will be a deemed sanction. So they've also incorporated in 167 CrPC, that old 167 CrPC, Supreme Court judgment of this Balaji Senthil, that the remand of 15 days can be during the broken period. So whatever Supreme Court judgments have come in between, they have beautifully incorporated it. But my problem is that this section 200 has been amended to 233, which makes a very interesting reading. It says there is a proviso they have inserted that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. It's a great, first of all, practically, it is somehow, I feel that they are wrong. They should have made it a subsection in the summoning section. They should have not have made it in 200. And if they are using it in 200, they cannot use the expression cognizance. Because in 190, cognizance has been taken, then you come to 200 for the examination of complainant. If they wanted, either they added, I think they wanted to do it for summoning, but because of this error, which normal law students do, of the cognizance and summoning, they said cognizance. And moreover, when they made the said so, they should have said it in 190, even if they wanted to say cognizance, but they said it in 200, so which is 223. This provides no cognizance shall be taken without giving the opportunity of being heard. Now, even in a 138 NI Act case, or in any case, you file a complaint today. Suppose evidence is on by way of affidavit, or the evidence is recorded. After that, the judge summons the person, then the accused gets the right of audience. And suppose 1,000 complaints are filed in Delhi. The summons are issued in 100 also after a few months, and then they go and engage the lawyer. Now, please be clear. 100 complaints filed on a particular day in Delhi, 10 accused, that means 1,000 people. So they require lawyers. Somehow I feel for the complaint cases, the Delhi will be short of lawyers. They will have to kidnap lawyers to do their cases. Whatever complaint case is filed, immediately on the filing of a complaint case, the judge will have to call the accused person. And I'm not able to understand, a complaint can be filed against 5 people and the 6th person can be the unknown accused. So I don't know to whom the notice will go in case of an unknown accused. But for whatever complaints are filed, immediately a notice is issued to the accused. So now the people will be queuing. See, a person comes to a criminal lawyer's office when there is a FIR or there is a summons. Now the person will queue up before a lawyer's office, criminal lawyer's office. So saying that, oh, a complaint has been filed against me. So you will go and conduct a mini trial. So what is the scope? So this provision is I don't think that they thought of this. They are saying that they are going to do the speedy justice. This is going to delay. Now there should be either only FIR. We should say goodbye to complaint cases. But there is one thing is good, that for the benefit of the public servants, they have added a specific section that the cognizance will not be taken unless it is committed in the course of discharge of duty, unless public servant is given an opportunity. So, what person, I am not able to understand this, that for a public servant is given an opportunity, so that is for anyone, that provision is for anyone also. But there is one more thing also. A report containing facts and circumstances of the incident from the officer superior to such public servant is received. So this provision, this is also there, but somehow I feel that is already done in case of 197. They have diluted 197, but they have added it here. So you cannot get a public servant now summoned easily. 1. 2 is, so whether 197 or no 197, this is one thing. Now, second thing is that for this cognizance, you have to call the person beforehand. And of course, there is now they've added 227(1), that is summons or warrants can be issued through the electronic means. Then there is one more thing. This is a step towards the speedy justice to say, and this would also create some confusion. Now they say that for magistrate tribal cases, I could not find this provision in the sessions tribal cases, but for the magistrate tribal cases on the basis of a police report, as well as on the basis of a complaint case, they say that the moment the documents are supplied to you, after that, you have to prefer the application for discharge within a period of 60 days from the date of supply of copies to you. So this is I would say a little welcome step, and then again the lawyer people will be queuing up, because the moment the person is summoned, so it takes 3 years or 4 years. But at least you have to move the discharge application. They don't say that the charges have to be decided in a particular time frame. So the application for discharge is to be moved immediately. So now the moment the case is filed, so the clients have to run to the lawyer's office. So to move the application for discharge, because within a period of 60 days, the application for discharge ought to be filed. So these are some basic glaring things which I found. And my basic comment is that why are they making us unlearn all these sections? We knew all these sections by heart. So this purpose they could have achieved by introducing the amendment. I don't see the purpose of putting the old wine in new bottle and changing the label and everything. They could have added, they could have made a cocktail. They wanted to add some vodka or whiskey or whatever more, they could have added that, but no, they did not want to. So they wanted to change the basics so that everything can be claimed of a new on own. So regarding that, I'm not very happy. We'll have to remember all these sections again And we are so used to the way we appear in the court. We've argued 2 cases before a male judge. We are saying my lord. So then we go before a lady judge. Then also we end up saying my lord. And with me, it so happens that you argue before 2 lady judges. You are saying my lady. So you go before a male judge. You again happen saying my lady. So this is the problem. And the problem happens that when there is one judge is a male and one judge is a female, you are appearing before a division bench. So you don't know. You say my lord or you say my lady. So the same thing is, so it is on our tongue. So this CrPC and also we'll keep on saying CrPC. So saying BNSS or BNS, I'm finding it little cumbersome because it is not so at this age, at this old age, they are making us unlearn everything and then remember new numbers, but then we'll have to do that. So it is not that a new mobile phone has come, so you can copy the contact, you'll have to type the contacts again. So that is what I wanted to say. Thank you. Thanks for recommending.
Thank you, Vijay bhai. Thank you, because now the time is there that you have to learn, relearn and unlearn. And what you are saying is a problem which Mohit must be facing, that everywhere this issue is coming, that advocates are not making complaint of the law. Always are complaining, making the law that earlier I have remember 420, now this is the different section. So this is one problem. So Mohit, over to you and your view on this particular law. And you as a president of Delhi High Court Bar Association must be receiving the different types of problems. Over to you.
Thank you, Pawan bhai. In fact, a couple of things which I wanted to address, Vijay has very beautifully already enunciated them. You are right, and I would agree with Vijay also in this regard, that much of the wine in the new bottle is the old wine, but a different color and probably a more with the going in trend with the nationalistic fervor of removing the English language and making it more desi product come out. But what we as counsels and lawyers face, and since you have already heard a judicial officer, a high court judge, having given the aspects where a lot of castigation was done on the lawyers and their presentations and their seeking adjournments being a key factor. I'd like to add a few things, that what seems to have weighed in the mind of the government in bringing it this new set of laws is perhaps trying to make something more comprehensive. Whether they have succeeded in it or not will be a thing which one will have to examine after going through a little time, trying to test it on time. But some aspects which come out very, very handy, and I believe have been seen in the past in the papers also, people would see, is the aspect of sentencing. What we have seen in the past, and as one honorable judge in Delhi High Court had taken the planting of trees as a kind of act of remorse and act of work towards the society, community service is now added. Now, community service on the aside had been going on by the high courts in exercise of their constitutional powers. They had been giving this sentence as a punitive, more like something in a via media, when they wanted to go a little lenient. Now, bringing this in the Bharatiya Nyaya Sanhita, I think helps even the trial courts to hand out the sentence of community service. When you feel that the offences do not actually, or the conduct of the party, the defendant doesn't require a very, very heavy hand. It's pretty helpful. So that is somehow, I feel, is a very, very welcome thing. Another aspect which I find, and in addition to what Vijay has already said, is the aspect in the BNSS, the Nagarik Suraksha Sanhita, the chapter relatable to the investigations of the police. Now that chapter, which relates to the investigation by the police, the chapter 13, which used to be chapter 12 in the earlier code, starts with section 173. Now, what used to be 154, where the FIR used to be registered, a very, very comprehensive section, according to me. What they have done is perhaps taken all the amendments into the frame, and rather than having those capital A's and the starred sections where the amendments were brought in, they have made it all in a one comprehensive section, 173. And one would find something very welcome, and which Mr. Agarwal would have been in a better position to answer, and in fact tell the people, is what we have learned as practitioners. Getting an FIR registered after the police refuses to register it in the normal course by approaching the court under what used to be called as section 156(3) CrPC is today now 175 subsection 3 CrPC. And what I find is something actually good in that is that they have added the satisfaction of the magistrate while directing an investigation by police by registration of an FIR, with what they have added as making an inquiry as he thinks necessary and recording the submissions of the police officer. Then only he'll order such an investigation. That has been agitated by counsels across the country in high courts, saying that in commercial matters, which are essentially civil, the police is being introduced. And interestingly, police used to say in their initial reports that this is essentially a civil dispute. Yet FIRs would be registered because the perception of the magistrate would be that the man who's making the complaint is making a complaint with genuineness. But later on, it was used to be found that this actually had that he had an axe to grind. Now, wreaking vengeance through criminal law is not something which is can be allowed, and it is deprecated. So I would say that this introduction of a safeguard here is definitely useful, definitely good, because it will reduce a lot of burden both on the investigating agencies as well as on the high courts, where the challenges to such orders are taken. Another place where I feel that some kind of a semblance of maturity is shown is where the exception of marital rape, the age has been raised to 18 years from 15 years. I think the initial period of 15 years was keeping in mind the aspect that much of India has a lot of customary practices where the girls are being married off at a younger ages. And the ages of puberty was being taken as the ages where they would consider that beyond that they could be married off and all, though it was an offense otherwise. But this is somehow, according to me, also a good reason to deter people. Rather than going in for girls' marriages at a much younger age, it allows them to probably bloom much as a personality, as a character, do something for themselves in their lives, rather than get married fast. Now, this would be a deterrent, I think, also for the families where they want to push their daughters out for marriages early in life. This is something which I feel is good. However, in the same breath, I would like to say that the aspects in the enhancement of punishments in what is section 64 now, which used to be section 376 of rape, in the offenses relatable to minors, there is an introduction of death sentence. I somehow, as a counsel, defense counsel primarily, and also, I feel that capital punishment should be in the minimum number of cases unless and until you find that there's something really gross. And another reason for my holding this opinion is we have POCSO as a special statute. When the special statute was incorporated, was brought in, and that special statute had stringent measures and was looking into the aspect of crimes against children, the sexual offenses against children, there was no provision or contemplation of a death sentence. When a special law did not contemplate that, I really wonder why and what weighed in the minds that in a general law, this death sentence has been introduced. Because death sentence is by itself has to be in rarest of rare cases if the standards have to be the same. The introduction of death sentence somehow belies logic. Also, another thing which in this regard I'd like to say is that rape or any such sexual offense is more relatable to a mental perversity. We unfortunately have had occasion to find that there have been introduction of sections of rape as offenses, even in matrimonial offenses, where after the amendments in 2013-14, 376 and 377 have been very, very commonly and often used in the disputes among spouses. So, without keeping that aspect in mind, that we need to prevent the misuse, here we are giving much liberty to misuse it even further. And there was a celebrated case where a wife had actually asked her daughter to raise allegations of sexual assault against the father. And the High Court had to step in. Even in POCSO today, it is being misused, and there have been instances. So increasing punishment first must be, I think, protected all across and all around, with safeguards where an innocent man should not suffer on account of this, and this should not be used as a handle to make their compromises and their adjustments and their settlements of other issues. Now, one aspect which I am sure it's found its way in the discussions is on the aspect of authorities given to the police. Vijay has covered a number of aspects where a lot of power is given to the police. He's covered 111, 112 of the Nyaya Sanhita, BNS, where 2 offenses or 3 offenses would become an organized crime. And there is a normal organized crime, which is the serious ones, and then there is a petty organized crime under 112. He's also highlighted the aspect of a sweeping power to the investigating agencies to attach properties. Now it will not be restricted to only those offences which are in the scheduled offence, but it will be across the board in the offences in this code or this Samhita. I stand corrected. There is another power which has been given is in the aspect of taking remand of the accused after he is arrested, and investigation, which used to be in the terms of section 57 to be finished within the 24 hours, is now section 58, the amended one, which is the new section 58, which says within 24 hours you have to conclude. If you do not conclude, what happens used to be under 167 of the old code. And most practitioners would know that there used to be a concept of default bail. In case the offences are not investigated and completed, the investigation completed within a span of 60 days or 90 days. Thankfully, the lawmakers have not changed that period of 60 days or 90 days, except authorizing the extension by the courts. But there is a slight modification they have done to the diktat of Anupam Kulkarni's judgment on the point of remand in police custody for 15 days. Now, the judgment originally allowed that 15 days to be in the first 15 days, the police custody. It could not be after the 15 days expiry, whereafter it would only be judicial custody. So that interchanging custody was in the first 15 days only. Now that has been enlarged to 40 days or 60 days out of the detention period permissible under 60 days or 90 days. So in the first 40 days or in the first 60 days out of 90 days or 40 days out of 60 days, that interchangeable 15 days police custody can be taken. That is probably, and that we are only hypothetically speaking, because we do not have the basis, or there are no debates on this aspect in the parliament, because from whatever we have read, there were no debates on a section by section wise, and we have no access right now to the parliamentary committee which discussed it, what weighed in the mind. But just as a contemplation or probably conjectural, that this 40 days or 60 days was perhaps at the behest of the agencies, the investigating agencies feeling that they may not have sufficient ground to seek the custody in the initial period, or they may unearth something more in the next 15-20 days. So if they unearth something after the man has gone into judicial custody and a period of 15 days, or maybe let's assume they had taken 7 days police custody in 2 parts, 3 days and 4 days, or 4 days and 3 days, whatever. And after that 15 days expire and he is now in JC. Now they uncover something and they want to confront him. They had to take permission, and if the man had denied, he could refuse. He could remain in the judicial custody and refuse any kind of access to the agencies that he doesn't wish to answer. Probably, and this is again hypothetical, that the agencies wanted that the remaining 7 or 8 days that they still had, they may be allowed, or they should be allowed, that if somebody else is caught or some other accused comes up or they unearth some evidence, they want his 1 day or 2 day police custody again. So they allow that interchangeable custody, which is restricted to 15 days, but it could be invoked at a later point of time. I would say, and this is where I'm only hoping, that the intent of the lawmakers was for a fair investigation, and the courts also strictly monitor it. This 15 days should not be for the asking. Remand to police custody should be in the strictest of manners, because a person's liberty is at stake. He may be asked to self-incriminate himself in that period, or he may be coerced into it, or he may be under pressure or duress of any form. So keeping that in mind, when you tinker with the law, there has to be a fundamental basis behind it. There has to be a cogent reason for it. So since there is no background to it, I can only presume that this was in their mind, that they may uncover something else and they want to do it. Now, having added even the offenses like I think it was 113, where they have added the offense of terrorist act. Now, unless and until the intent is to do away with all those acts, itself, that we do away with the UAPA and all, unless and until that is the intent, I really don't understand what is the purpose, because this section 113 is somehow, it is a conglomeration of the sedition laws as well as the terrorist acts, the UAPA, unlawful activities, section 15, etc. So now, Vijay has pointed out Mokoka being brought in, he's pointed out the PMLA part being brought in, the attachment of money laundering. And this is what I am trying to bring into you, that this terrorist act is defined. So unless and until the intent is to have one comprehensive law and do away with all these special laws, because the word for cognizance also has been for special laws. Unless that is the intent, there's going to be a duplicity, there's going to be confusion, and I dare say that litigation might stall and delay proceedings rather than if the intent is to somehow finalize it and conclude it fast. Because fixing timelines may not be just in the same manner, because we are dealing with the liberty of a person. So keeping Article 21 in mind, which is the Grundnorm, the supreme law, the Constitution, I don't know, having duplicate laws, multiple laws, and then the yardsticks being varying may be difficult. So the government will have to come out clearly about it. So these are aspects which I thought I must highlight for all of you to apply your minds and then probably take this law further, because now this has become the law, only needs notification. So with that, thank you, Pawan Bhai, and thank you everyone for bearing with me. Thank you.
Thank you, Mohit. Thank you very much, because you people are expert day to day appearing. So between the lines, you people can read better and you can suggest also. So because this is a program which we have organized, so people should understand. So Vivek, please stop the voice. Vivek. Okay. So now I will request Amit Khemka ji to.
Thank you, Pawan Bhai.
Thank you. So to share your point of view. You have to unmute yourself, Amit ji.
It was absolutely wonderful listening to the two stalwarts, I think Rameshji somehow is not anymore linked. It would have been pleasure to listen to him as well. Now, it is absolutely clear that we will no more have 302. It will be called 103. अब 420 नहीं होगी.
313
Now it will be, अब ये 318 होगी. So the thing is, as was pointed out by the speakers before me also, that not much has been achieved by changing the numbers. Because at the end of it, almost 90% of the sections and 90% of its matter remains the same. So the same thing could have been achieved by keeping the same numbers, because it will be a process of unlearning and learning again for people like us who have spent 4 decades in the profession. And we recognize law by numbers, by section numbers.
Yes.
So that is one very difficult thing. The first speaker was all out. He gave vent to many of his feelings, which he might have encountered as a judge. But it is very easy to blame any one community. There can be many things which can be said about how the judges deal with the matters. Now, take for example, I've always wondered that enforcement department files a 20,000 page complaint, or CBI files a 10,000 page charge sheet, and the honorable judge is able to take cognizance of that matter within a matter of hours.
Yes.
That clearly shows that there was no application of mind, and it was done in a very mechanical manner. It can be said that the judges, a charge sheet is filed or a complaint is filed with 150 witnesses in it. And those witnesses, the judge does not even ask the IO as to what is the relevance of these witnesses. Why do you need so many witnesses? Now, coming to the 3 new laws, this is what I, as a lawyer practicing in the courts, in the litigation courts, would have expected. That trials were made simpler, trials were made more concise, trials were made more systematic. Like, for example, more than 50% of the witnesses in every trial are formal witnesses. In Civil Procedure Code, 2 decades ago, we introduced the system of administering the examination in chief by way of affidavit. Now, these formal witnesses can always give their examination in chief by way of an affidavit. Now, something like that would have been really welcome.
Yes.
Something like a system of admission denial in civil matters. Now, we do cases of, say, PMLA or CBI matters. In that, most of the evidence is documentary. Hardly any evidence is in the form of the oral evidence. So there can be a system of admission denial, which actually exists. And that can be made more robust so that the oral trial, the duration of oral trial is minimized. I would have expected something like a time limit to every investigation. Unless we have cases where the Enforcement Directorate has been filing supplementary complaints after supplementary complaints for 8 years. They have filed 5 supplementary complaints in one single prosecution complaint. There ought to be some limit. The people are being called to the court every day, on every date. And then another charge sheet, another complaint comes, another supplementary complaint comes. So I would have expected, if you wanted to make some changes, people like Mohit Mathur, people like Ramesh Gupta ji, people like Vijay Agarwal ji, we people should have been consulted. The inputs from these people would have made it a better exercise. Take, for example, the Supreme Court of India has been repeatedly saying for last almost about 20 years that investigation should be separated from law and order. No government, no state government, no central government has ever said that this insistence of the Supreme Court is wrong. But then there is no acceptance thereof as well. I would have loved if these new laws had incorporated something like separating the investigation from the law and order maintenance. Look at an irony. A 23-year, 24-year-old young sub-inspector is handed over a file for investigation. And a 40-year-old pot-bellied sub-inspector is asked to run after an accused. While his experience should be utilized for the purpose of investigation, and his energy should be utilized to run after the accused. This is what the Supreme Court has been saying. And this is what should have come in these new laws. Some method of trial should have been introduced. The trial, we see every day that 3 witnesses are called for a day, 2 have not turned up, or all three have not turned up. The counsel has prepared the cross-examination. It is very easy to say that the counsel is asking for date. But look at it. Yes, sir. Mr. Ramesh Gupta ji is there. Let us take him. Bilkul, sir, bilkul.
Ramesh sir.
पहले उनको ले लेते हैं सर.
हाँ. Ramesh Gupta sir.
Gupta sir.
So I think double connection will be there, so just disconnect one connection. Yeah, now it's okay, sir. Over to you, sir.
Sorry, I could not hear the other speakers except that I heard a little when Vijay Agarwal was there on the mic. I think you must have a seminar or whatever it is for Vijay Agarwal alone for 1 or 2 hours so that we can learn. He studies very deeply. In fact, I have not before today read all these three acts. Because I was very, very critical, because I felt that there was no need of changing the name or the acts at all. They could have deleted certain sections, they could have added certain sections. And most of the sections could have remained the same. Like not only a lawyer, in whole of India, everybody says 420, everybody says 302. Everybody, rich or poor or uneducated, educated. So 482, 438. There are so many sections which by habit even non-lawyers know. And you suddenly change the section without changing anything else. Serves no purpose. I was just today only studying some portions of CrPC. Like I was of the view that by now the legislation or the government should have realized that there are so many sections which should be allowed to be compounded, like 498A. And I can tell you, if you collect the data, if in Delhi alone, maybe 500 cases are registered in a month, later or sooner, all the cases goes to High Court for quashing. Why time of the High Court should be wasted? Similarly, hurt cases. Similarly, so many cases, 307, 308, they go to High Court for quashing. And every High Court on the criminal bench, I think I'll say waste at least 1 hour daily on these cases. And 99.9% cases, the High Court allows no quash, compounding. Because even the Supreme Court and High Court says that the litigation should come to an end and people should be encouraged to compound the personal litigation. So in 320 section, which was amended to other section, I have find that some sections have been added like 379 was added, but no other many sections like 498A was not added. So they could have added more sections in 390, earlier 320. Now I'll have to read what section. 320. कौन सा है 320 का बताओ? 1 minute. Because in my life I won't be able to remember the new section. 359. 359 now here this whatever you call the new. 359, as I read, some sections like theft have been added. The 303 is very good. Some for cheating and misappropriation have been. They should have added forgery also. In many cases, wherever there is 420, there is forgery allegation also. So they could have added. So my first view is that while they were amending, after 73, let's say, 73 also, some sections were added, some were amended. So they could have done the same. But nevertheless, now, after it has been passed by the parliament, I think we have we are not supposed to criticize it. Only thing is we have to interpret it. I remember one day at around 2:15, I received a call from some lady claiming that she is from Ministry of Law and she wants my view on the proposed amendments. I said, fine, I'll do it in few days. She said, no, by 4 o'clock we need it. Means at 2:15. Phone I received and 4. She said, no, by 4. I said, it's not possible. So they were only just doing the formality. They must have said that we have asked so many people. That is the situation. But nevertheless, I have some, like Vijay said, section 200 earlier, CrPC. Now, sir, kindly I'll read again that section. Now 223. Very interesting. You see, one more thing. CrPC was enacted late back, maybe hundreds of years. Then amendment. There are so many interpretations by the Honorable High Courts, various High Courts and Supreme Court. And the Supreme Court is very clear on certain aspects. They should have amended those sections in which Supreme Court has laid down the law. But what they have done is 223. a magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine on oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant, provided that no cognizance of offence shall be taken by the magistrate without giving accused an opportunity. I don't understand what they mean by it. At the initial stage when complaint is filed, then he has to give notice to the accused persons, or when he decides that the cognizance has to be taken, or summons are to be issued under 204, like now 227. So it is very, very ambiguous. I agree with Vijay when he says that it will be impossible. In Delhi, 138 cases, I think, maybe in thousands daily cases are filed. So in years together, summons will not be even served and they will not be an accused. You see, till they are summoned, they are not an accused. They are only the respondents. See, you file a complaint, so they are respondents. They will be accused when you are summoned. So I don't understand what is meant by no cognizance of offence shall be taken by the magistrate without giving the accused an opportunity of being heard. At what stage? Provided when the complaint is made in writing, need not to be examined and witnesses, if that is provided that the magistrate taking over the case to another forum. So I don't understand. But in any case, but I think there is some safeguard as far as complaint against public servants is concerned. Now, one positive thing I found was in earlier section 167, now it is 167. 1 minute again, let me check. 167, 187. It is very important section. (187) Hanji. So in 187, you see, normally we always, when charge sheet is not filed in 60 or 90 days, we come to the court for statutory bail. And there was always a confusion when earlier it said that if offence is punishable with death, life, or up to 10 years, minimum 10 years. Earlier section was 167, for a minute. For a term not less than 10 years. So now they have substituted for a term of 10 years or more. So that ambiguity has been cleared. Because when it was said not less than 10 years, in some judgments, so Delhi High Court and Supreme Court said it can be up to 10 years. So that was a wrong interpretation, but nevertheless, it was an interpretation. Now they have said for a term of 10 years or more, means any offence which is punishable with minimum 10 years. So it will be minimum 10 years. So not less than 10 years means, now they say up to for a term of 10 years. So it has made clear any offence which is not punishable for 10 years or more, then 60 days will be applicable. So this ambiguity has been removed as far as this section is concerned, 167, now 187. Otherwise, I think there is no other change which I can see. Now, section 82, which we call, where provision the accused could have been declared pure. Now, I think 84 section is there. 84, proclamation. In this also, earlier there was ambiguity. Now, as I read, maybe if Vijay is there, he can correct me. कहाँ फुर्सत होगी भाग्य होगा. Proclamation for person absconding. In this section, earlier 82(4), proclamation was for particular sections. Now it has clarified 84. 4. Where a proclamation published in subsection 1 is respect of a person accused of an offence which is made punishable with imprisonment of 10 years or more, or imprisonment for life or death under Bharatiya Nyaya Sanhita or under any other law for time being in force, and such person fails. So only that person who is accused of an offence of 10 years or more and life or death, only he can be declared proclaimed offender, and not other, either in special law or under this new Sanhita. So this ambiguity has been removed, and I think this is my interpretation, that a person who is not accused of offence less than 10 years, he cannot be declared proclaimed offender. You can take warrants of arrest, that's fine. So therefore, this appears to be a change. And what else I can say? One more thing. While you take police remand under 167, now new section, as I was reading, is again भूल ही जाएंगे ना सारे. 167 का हो गया 187. (167) is replaced by 187. It says, and earlier also said, that when police officer asks for a remand, he has to produce case diaries. Earlier also it was there, and they have not changed it. Same. He says that case diaries has to be maintained in a diary. 192 section now. The statements of witnesses recording during the course of investigation and the verdict shall be inserted in a case diary. The diary referred to shall be volume and duly paginated. No police officer maintains a case diary, CD, which you call. They have the loose papers and they fix it with the charge sheet and police file. But earlier CRP also said, this also says that it has to be a volumed and paginated diary so that they cannot temper the case diaries. And statements of witnesses has to be incorporated in the case diaries, and not that you have to annex it with it. Earlier also was the same provision, but the police officer says, हमें तो मिलती नहीं थी case diary, हम कहाँ से लिखें? Judge also says कि अगर नहीं मिलती तो हम क्या करें? अरे, when there is a law, earlier was 172, then you, and it is a procedure. You are amending, you are changing the law procedure also, and then you don't understand that it is a compulsory requirement. So I say that after so many years, when this amendment has been incorporated, still you are incorporating this. The legislation could said that it is not possible for any police officer to have the diaries. It can be only loose papers and only, okay, by hand he can give number 1, 2, 3, 4, 5, 6. It is not done. So what I feel is they have incorporated again the same thing. So it should be followed. Then 41A, which is very important. Before that, 173, which we say charge sheet. Now it is 193. What makes the difference between 173, 193? You could have kept the same. But it also important. Again, there is a confusion and interpretation. It says that investigation relating to an offense under 64, 65, 66, 60, these are, I think, rape cases, and protection of child shall be completed within 2 months from the date on which the information was recorded by the police officer. Which means what? even if accused is arrested or not arrested. You have to file a charge sheet in 20 months, 2 months. Shall be completed within 2 months from the date on which information was recorded. So it doesn't talk of that after arrest of accused within 2 months you have to investigate. It says after registration of FIR, within 2 months you have to complete the investigation. Either accused is available, no available, accused fined or no fined, you have to file charge sheet. If this is so, then rest. So I don't think what will be ultimately interpretation of the court, but I say that there is some very strong confusion. Then again, sir, in earlier 173.8, now it is 193.9. Nothing in this section shall be deemed to preclude further investigation in respect to an offence after a report under 3 has been forwarded to the magistrate, and whereupon such investigation the officer in charge of police station obtains further evidence. Oral documentary shall forward to the magistrate a further report regarding such evidence. So that means after filing a charge sheet within 2 months, when accused is arrested, or even if it arrested, he can further investigate. But the investigation during trial may be conducted with the permission of the court trying the case, and same shall be completed within a period of 90 days as the case. So I don't know what the trial means. Trial normally interpretation is only after charge is framed or notice is given, only then trial starts. Before that it is inquiry. So again, even after charge is framed, the further investigation can be ordered. But so far, law was that no further investigation is permissible after charge is framed. So this is again a very, very, I think, confusing. And we'll see what, and in my lifetime, I'm almost 75, 50 years in profession. Maybe few years I'll be in profession. Again, problem will be that old cases so far, which is in millions, the trial will be in the old acts, and the new act trial will be after it is implemented, or from what date it will be a new act. So in my state court, we'll have both the evidence act, CrPC, old and new. The judge को भी बताना पड़ेगा अहमद को कि ये नए वाले अलग रखो, ये अलग रखो, ये नए वाले लगाओ, एक दिन पुराने वाले लगाओ. So और हमारी लाइफ टाइम में तो ये कंफ्यूजन ही रहेगा. नेगोशिएबल इंस्ट्रूमेंट एक्ट आया था 1997 में. एमडीपीएस एक्ट आया जब मैंने वकालत आलम शुरू की थी 86 में. आज तक इंटरप्रिटेशन हो रही है सेक्शंस की. 138 की आज तक इंटरप्रिटेशन हो रही है. तो इनकी इंटरप्रिटेशन होते होते हमारी लाइफ तो एंड हो जाएगी. बट नए बच्चों को भी बड़ा दिक्कत आएगी, क्योंकि जो भी आज प्रोफेशन में आएगा उसको कम से कम पुराने केसेस भी 15 साल तो करने पड़ेंगे और नए भी करने पड़ेंगे. तो अब क्या इसका पर्पस है क्या नहीं है, बट एज ए क्रिमिनल लॉयर आई कैन से दैट इट विल नॉट अचीव एनी पर्पस, रादर इट विल बी ओनली creating lot of confusion, lot of multiplicity of litigation, lot of appeal, revisions, 482, now whatever it is. So as a lawyer, I can say that it will not be serving any purpose. They could have, of course, keeping in view that there are so many litigation, so many cases, would have created such a situation that there could have been an early trial. There could have been, like, plead guilty. I can say that sometimes एक स्टूडेंट मेरे को पूछता है अप टू 10 years में क्या जज एक दिन की भी सजा दे सकता है, 10 साल भी दे सकता है, वो ज्यादा रिस्ट्रिक्शन है. आपने क्यों नहीं ये कर देते कि इफ यू प्लीड गिल्टी, प्ली बार्गेनिंग का था पर उसमें बड़ा लिमिटेड सा स्कोप है. सिंपल सा है कि आप इफ यू प्लीड गिल्टी एट दैट स्टेज यू कैन बी अवॉर्डेड मिनिमम सेंटेंस, बट इफ यू क्लेम ट्रायल देन मिनिमम सेंटेंस विल नॉट बी अवॉर्डेड. मैं मानता हूं कि 20% लिटिगेशन कम हो सकती थी, कम से कम 20% लिटिगेशन. अपने क्लाइंट को कहते देख ले भैया अभी तो ये 2 महीने में बच जाएगा, मिनिमम सेंटेंस में जज को रिक्वेस्ट कर लेते हैं, अदरवाइज तो तेरे को ट्रायल क्लेम करेगा तो ज्यादा सजा होगी। ये प्रोविजंस आने चाहिए थे। पर मैं ये समझता हूँ कि जो लेजिस्लेशन डिपार्टमेंट में बैठे हुए ऑफिसर्स, उन्होंने वकालत तो की नहीं होती, उन्होंने सिर्फ झाड़ी होती है, मतलब लेजिस्लेशन में बैठ के सेक्शन इधर उधर करे होते हैं। हो सकता है इन्होंने 2-4 किसी जजिस को कॉन्फिडेंस में लिया हो, वो तो मैं इसके बारे में कुछ नहीं बोलूंगा, उनको भी वकालत का एक्सपीरियंस नहीं होता, ज्यादा एक्सपीरियंस होता है इंटरप्रिटेशन का। तो मेरे हिसाब से, मैंने अभी पढ़ा नहीं, आईपीसी नहीं पढ़ा, मैंने एविडेंस एक्ट नहीं पढ़ा। एविडेंस एक्ट को तो अगर इन्होंने छेड़ने की कोशिश की होगी, वहां खराब ही किया होगा। मैं एक बात कन्फेस कर सकता हूं अमित जी, आज तक मुझे सेक्शन 10 की इंटरप्रिटेशन समझ नहीं आई। आज तक कोशिश करते हैं, बट डिफिकल्ट है। 24, 25, 26, 27 तो आ गई, सेक्शन 10 तो आता तो है, पर वो जज को समझाने में बड़ी दिक्कत आती है। तो तुमने कहीं पर भी अगर उसको छेड़ा होगा एविडेंस एक्ट को, तो उसको खराब किया होगा, ठीक नहीं कर सकते।
Because that's one of the best drafted act.
हाँ, नहीं है। आप, अब मैं यही तो कहता हूँ, इट वाज एन इन्वेंशन, और जिसने सर्व किया पर्पस को, हमारे 200 साल, 150 साल, 250 साल, इट हैज सर्व द पर्पस। आज भी जुडिशियली हिंदुस्तान की वन ऑफ द बेस्ट है। वो ठीक है, प्रेशर ऑफ वर्क से नहीं हो पाता, तो इट हैज सर्व ऑल द पर्पस। आप उसको सिंप्लीफाई कर सकते थे, फास्ट कर सकते थे। फास्ट तो है, पर काम इतना है जजिस का। आप 309 सेक्शन था कि भाई जिस दिन आप चार्ज लग जाएगा, एविडेंस की डेट दोगे, डे टू डे करोगे। आज इन्होंने चेंज तो कर दिया, अगर वकील नहीं आया तो भी एविडेंस रिकॉर्ड होगी, अगर दूसरी कोर्ट में तो ग्राउंड नहीं होगा एडजॉर्नमेंट का। अरे पर जज कितना काम करेगा जिस दिन तुम, मैं कहता हूँ वकील भी खड़ा है, गवाह भी है, आप नहीं करते। आप 2-2 महीने की डेट देते हो, 3-3 महीने की डेट देते हो, 4-4 महीने की डेट देते हो। इसलिए एक जज कितना काम कर लेगा? अगर उसके बाद 200 ट्रायल है तो वो क्या, मैं तो कहूंगा करो इसमें 309 जो पुराना सेक्शन, अब जो भी इन्होंने चेंज किया होगा कि 309, 346, अब 346 देख लो। 346 में इन्होंने वकीलों पे तो डाल दिया, वकील नहीं आएगा, जज कहेगा वकील को बुलाना। अरे दूसरी कोर्ट में है जी, मुझे नहीं पता, चलो जी क्रॉस ले, वो तो कर देंगे। पर जब मैं कहूंगा चार्ज के बाद नहीं जी 7 दिन के लिए लगातार कराओ, मैं करूंगा, वो नहीं करेंगे, कहेंगे और नहीं केस है क्या? ट्रायल ऑफ ए पर्सन नॉट कंप्लाइंग विद मी, 346। अब ये देखिए, the fact that the advocate of a party is engaged in another court shall not be ground of adjournment. आप 10 बजे आके बैठ जाओगे कोर्ट में, जज कहेगा जी मेरे पास 3 हो रहे हैं, मैं तो बाद में लूंगा, तो इज इट प्रॉपर? या आप कह दो, या टाइम दे दो कि 12 बजे होगा जी आपका केस शुरू, या 11 बजे होगा, या 10 बजे होगा। कोई जज तो एविडेंस के पहले ले लेता है, कोई चार्ज के पहले लेता है, कोई कहता मिसलीनिंग करूंगा। तो हाउ इट इज पॉसिबल? तो ये सारा का सारा, दिस इज टोटली अगेंस्ट द बेसिक स्ट्रक्चर ऑफ ट्रायल, आई कैन से, where a witness is present but a party or his advocate is not present, or the party or his advocate though present, court is not ready to examine the is not ready to cross the court may think fit record the statement of witness and pass such order think fit dispense. What is this? तो जहां जज की मर्जी होगी, जहां पे लाइफ इम्प्रिजनमेंट होनी है, डेथ होनी है, तो नहीं ग्रांट नो एग्जामिनेट एक्सेप्ट वेयर सर्कमस्टेंस बियॉन्ड। तो बियॉन्ड कंट्रोल जज तो कह देगा मैं तो नहीं कर सकता बियॉन्ड कंट्रोल, बाकी दूसरा नहीं कर सकता। तो ये सारी चीजें मेरे को तो ऐसा लगता है कि कोई बहुत ज्यादा पर्पस नहीं सर्व कर रहा है एज फार सीआरपीसी इज कंसर्न, एक्सेप्ट जो मैंने आपको बताया। इसी तरह वो बेल का सेक्शंस में भी सेम ही रखे हैं, क्या मैं बताऊंगा। 82 तो अभी तो मैं ब्रीफली यही कर सकता हूँ, उसके बाद और समय मिलेगा अमित जी तो फिर करेंगे डिस्कस।
ठीक है, थैंक यू वेरी मच सर, थैंक यू योर wisdom of knowledge, wisdom and knowledge and your experience has explained this thing, and you have rightly pointed out that the overlapping things which is always there with the new law and old law, and we are seeing in so many other things. Thank you very much, sir, for joining. Amit ji, please conclude your point.
Sir, after such luminaries have spoken, there is very little which is left out. But I'll just point out few of the things which are very, very strange. There is a provision, section 303 in IPC, that if a life convict has committed a murder during the conviction period, he'll be punished with death. Now, this provision was struck down by the Supreme Court in Mithu versus State of Punjab. Now, that provision has again been brought on the statute book. There are at least two handcuffing has been brought back in the statute book. The solitary confinement has been brought back in the statute book. Now, all these are the provisions which Supreme Court had struck down in the past. What are you trying to achieve? You want the litigation to again start on all these topics. It is not going to give any relief as such, in my opinion, if all these issues have to be again deliberated upon by the courts. Because after all, people will approach the Supreme Court, High Court, and again the time of the courts will be wasted in deliberating over these. Then it is not clear as to what is it which you want to achieve. We claim to be a state where our system is reformative in nature. However, there were only 11 sections in the earlier IPC where death penalty was provided. Now, in the new law, it is 15 sections where the death penalty has been provided. So, while what should have been the main stress point, that earlier, 12 years ago, 13 years ago, there were only 65% under trials in the jails. Today, there are 76% under trials in the jail. So the stress should have been as to how to make things faster, how to make the trials faster, how to finish the trials. Now, there is no restriction on the number of witnesses which an investigating officer can cite. In all cases of Enforcement Directorate or CBI trials, there are 100, 150 witnesses, without even pointing out as to what is the aim. The magistrate would keep on mechanically just examining those witnesses for years after years. So there should have been some progressive thing where there should have been a provision where it should have been made mandatory for the IO to specify the purpose of citing a particular witness. It should have been mandatory for him to point out the purpose of giving a document along with the charge sheet or complaint to the court. Now, nothing of that sort has been done. I feel that it is more of, and most of my brother colleagues have the same views, that it is more of a cosmetic kind of a change. And it is really going to be very, very troublesome for people like us who have already spent 4 or 5 decades into profession. We know these numbers by heart, and now we'll have to remember these, no doubt, but we'll also have to remember the parallel provisions. So that is a very difficult situation. I don't know how we are going to cope up with it. But I think the time, I could have taken some more time also, but it is already 6:23. So, Pavanji, over to you. There would be, I can only say that there will be more litigation because of these legislations. It is not likely to solve the problems of speedy trial, and it may actually add to more delays in the trials. Thank you so much, sir.
Okay, thank you very much, Amitji. Thank you. Rameshji has also joined us, despite he has to travel somewhere and then he has joined. So all our speaker has joined and they have given their wisdom. Because we have over time already, we have surpassed. So I'll just ask you, Amitji and Ravi, two small question. One, the overall changes which they are proposing, all these problems are there, that the new law is coming, then old law and new law will go together. Section you have to remember again, you have to read it again. But I'm just asking you, any good thing is there in this particular thing? And Ravi, you prepare for technology point of view, any technological thing?
Yes, yes. What?
विक्टिम को जो जांच रिपोर्ट होगी ना उसका
Yes. See, that is there are of course few progressive things. One of them is it was pointed out by Mohit that one of them is in place of punishment, social service. The community service can be one of the punishments. So that is one quite progressive thing. Then second thing which is there is that the report of the investigation has to also be provided to the victim. So victim, who was till now was not a very big stakeholder in the police cases, will also be a stakeholder now, and victim will also be notified by the investigating agency as to the progress of the investigation. So there are other things also, and I cannot say that everything is bad, but it could have been achieved in a much better manner. And we are not against amendments. Amendments should be brought as the society changes. The amendments have to be brought. We are not against even the name change. Doesn't matter. But it could have been done in a more systematic manner than just coming out with sudden and rampant changes.
Okay. So you are also advocating of this point, in place of bringing the new law, they could have amended, they have removed, and they have added something. It could be a better proposition than changing the entire thing.
Yes, sir. So what I'm saying is that I had pointed out that the biggest issue facing, according to me, the criminal justice system is separating law and order from the investigation. That it is a must that there should be a specialized investigating agency, and the law and order people should be kept separately. This Supreme Court has been repeatedly saying, and there are repeated judgments after judgments on that. Okay. Because there is a very simple thing, sir, that a police officer who is throughout the day busy in the law and order maintenance, how can he also prepare the documents for investigation? How can he also be, available at the investigation point at the correct time? It is likely to interfere with both his duties. So investigating agency should be separate, and law and order machinery should be separate in the police itself.
Okay. So thank you, Abhijit. Thank you, Ravi. Last question. What are the technological changes they are proposing which can enhance the speedy trial?
The Sanhita, it provides in clause 532, if it is not changed after the committee's recommendation. Please excuse me for misquoting the number, but there is a clause which recognizes that all trials, inquiries, and proceedings may be held in electronic mode by production of electronic communication devices likely to contain digital evidence. So therefore, all the three stages of the criminal justice administration, there is a possibility that they could be now conducted through electronic means. But the committee also notes that while it is a welcome change on the paper, the system needs to establish robust safeguards and infrastructure, because the technology here is a double-edged sword. It is also susceptible to misuse. So therefore, so far as lodging of and furnishing the information is concerned, like registration of FIR, supplying the copy of FIR, issuance of summons and notices, all of this is still being transitioned to technology. Now, as good old days, I was not in practice in those days, but I think ever since I have been in the practice, I have seen reliance on technology for this. But I think the law seeks to take it to a next level. But the law and its efficacy is not how it pans out on the paper. It would be tested whether it is backed by the required infrastructure, whether people are accustomed to it, and whether it is easy or it is going to make things more complex and confusing. So therefore, although it lays down a compartment for more use of technology, the committee has clearly flagged some of their concerns regarding its misuse and the lack of adequate infrastructure.
Okay. Okay.
Pavanji, just to add a few lines. See, in Delhi courts, we are using the maximum technology. While Delhi and we are called the most pampered courts of the country. Is still the number of under trials in Delhi is the highest. So use of technology may not be the only guarantee of fast trials and effective justice. The main issue remains that what is the intention? The intention ought to be, the will ought to be, the vision ought to be to provide, to pick out the problematic things and ease them out. That has to be, just using cosmetic words, technology and all that may not be really the solution.
You're on mute, sir.
Muted, sir.
There are two questions. Some is specific provision should have been made for corporate economic offense, white collar crimes. The problem today is the preparing charge sheet under different laws such as Companies Act, PMLA, and matching that to other offense under IPC. Is it absolutely right? The suggestion is good because now you have divided things. So you require that one person who is a police officer, he cannot handle all types of cases, accounting cases and the law cases. The
question is very appropriate, sir. When the enforcement directorate officer, he records the statement of a person, he says that I'm not a police officer. But then when he arrests a person and takes him to the magistrate, he says, give me the police custody. So these kind of funny things ought to have been addressed by these laws. That whether these persons, you are in section 50, you are calling him that those proceedings of recording of a statement, they are judicial proceedings. While he is doing it worse than the police.
Okay.
So all these things ought to be addressed by if you are coming up with a new law, which have not been done, unfortunately.
Yeah. And one question which has come, they are saying, Advocate Ramesh sir has said if a person plead guilty, there could be a situation where he had been forced to plead guilty. This could be when an influential employer may coerce his servant or driver to plead guilty. Will it not be a mockery of law? I don't think the question which he's asking that anybody can compel to do this and accept the guilt. Okay, that anybody, Amiji, any view on this?
So that's an offense he is committing. He is committing yet another offense. And after all, if somebody is out there to commit an offense, he will face what he should face.
Okay, and the fiscal crime need to be separated from other cases. That is absolutely right. So, friends,
I think the new procedural law should have. I don't agree too much with Vijay on this, that PMLA should have been kept separate. Why couldn't PMLA have become part of the IPC itself? Why couldn't, I mean, it may be fiscal in nature, but you are providing one part attachment in the IPC now, in CrPC now, but you are not bringing the whole act here. Why are you having so many criminal laws? Why are you having so many criminal acts? You could have had one comprehensive criminal act, the law where all the offences are provided.
So I
So
think
there is-
Amitji, we have missed the bus. The
Yes.
point which you are suggesting, now this is the law and we have to face this and we have to face the
Of course
consequences
we have to.
and this. Okay, so friends, here we have to end. We have already crossed time, but very interesting. We have done the survey recently, just now, and there was 168 answered. Now, interestingly, do you believe that proposed repeal of Indian Penal Code and enactment of Bharatiya Nyaya Sanhita would be beneficial in addressing contemporary issue and providing swift justice? Now, this is a single choice we have, and 43% says yes, no 14%, and 43 was unsure. So I think yes is more, because if I'm sure, if you added, that will cross 51%. If I'm dividing 50-50 on this, 21.5, 21.5 to both the things, then it will cross. So the 168 people have said yes. Out of this poll, they have said yes, means 72 people, and 73 said unsure. So this is the thing. So here, thank you very much, everyone. We are closing here. I thank Amitji, Ravi, a special thank to Justice Dhingra, then Mohit Bakur.
And sir, a special thanks to Sunil Gupta ji also.
Sunil Gupta ji,
he has given lots of inputs to me on this.
Sunil Gupta ji is the lawyer, and he was a jailer in Tihar jail, and he has seen so many cases. He has, I think, which are the cases, sir, he has handled? Rangavilla,
last 4 decades, there have been 7 executions, 8 executions, and all 8 executions were conducted under his supervision.
Okay, so sir, one day we will organize one program on this execution also, and then what is the condition of the criminals and which you have faced, and what types of psychological trauma you have undergone, and simultaneously the culprit also we will have. And thank you, Sunilji, for giving this input to Amitji. It will be really useful for all, because this was a program which required complete full day, and we have a capsule program. So that's why we have done this in a very short manner and in a macro manner. So someday we will do micromanagement also on this, and we'll organize program on different aspects of criminal procedure code. So thank you very much all, and thank you Amitji, Ravi, Sunilji, Vijay, Mohit, and Ramesh Gupta ji, and Justice Dhingra. Friends, this is the program, and this is our knowledge share journey, and it will continue. So next Friday, that is 12th January, 4 p.m., we are having a webinar on consultative paper on amendment of SEBI regulation with respect of verification of market rumors. You are aware that market rumor issue has come, and this is creating a lot of problem. So we will discuss this issue, and we will give suggestion to SEBI so they can come out with the perfect and clear law. Till then, thank you very much. See you on Friday, 12 at 4 o'clock. Bye.